بسم الله الرحمن الرحيم. السلام عليكم ورحمة الله وبركاته. معكم فاطمة محمد الخاجة، رئيس قسم التخطيط والتدريب في إدارة التأهيل والتدريب في معهد دبي القضائي. يسرنا ويشرفنا أن نرحب بكم في الجلسة التدريبية بعنوان أفضل الممارسات الدولية في مسائل الأحوال الشخصية المدنية لغير المسلمين. تقدمها لنا اليوم الدكتورة لينا ماريا مولر، خبير متخصص في مسائل الأحوال الشخصية والأسرة. أود التذكير على أنه سيتم وضع رابط لتسجيل الحضور في خانة المحادثة، وعليه يرجى الضغط على الرابط وتسجيل الحضور. نسعى دائما في معهد دبي القضائي للتطوير والتحسين. سيتم تزويدكم باستبيان لتقييم البرنامج بعد الانتهاء من البرنامج. راجين منكم تزويدنا بالرد، لأن آرائكم وملاحظاتكم أكيد تهمنا. خلال البرنامج سنوفر لكم ترجمة فورية، حيث أن لغة البرنامج هي باللغة الإنجليزية. للاستماع إلى البرنامج باللغة العربية يرجى الضغط على الترجمة واختيار اللغة العربية من الاختيارات الموجودة ضمن شريط الأدوات في تطبيق زوم. سيتم إتاحة الفرصة لكم لطرح الاستفسارات وتخصيص وقت الأسئلة في نهاية الجلسة. يرجى استخدام خاصية رفع اليد لإتاحة الفرصة لكم لفتح الصوت. شكرا لحضوركم. والآن نبدأ هذه الجلسة التدريبية. دكتور لينا, thank you for joining us, and please, you may start now.
Thank you very much. Good morning, everyone. Thank you very much for the kind invitation by the Judicial Institute in Dubai. I'm very pleased to be here today. We have an intensive seminar, an intensive training session planned. As mentioned before, the topic will be inheritance law, and it's essentially going to be a global overview of best practices in civil inheritance law, and how this may inform civil personal status matters for non-Muslims in the UAE. So I will share with you first our agenda for today. Following a very brief introduction, I will be shortly, again very briefly, speak about the current legal framework, so the civil personal status law for non-Muslims in the UAE. Of course, I know you are all the experts on this topic, so I'm going to be very brief and only highlight those aspects that are relevant for our analysis today. And then we move on to the to the central part, the most important part of our training session, which will be a comparative analysis of best practices in inheritance law. We will look at common law jurisdictions and civil law jurisdictions and how they differ in testate and intestate inheritance. As case studies, I have selected England and Wales, common law jurisdiction, and then we will be looking at France and Germany as civil law jurisdictions. Turning to the United States, so another common law jurisdiction, and then we will briefly look at two other hubs for expatriates, and that is Singapore and Hong Kong. We will talk about some practical considerations in drafting and enforcing wills, and then move on to discuss key takeaways and your questions. So let us start immediately. Just a very brief introduction from my side. As mentioned before, my name is Lena Maria Möller. I'm a research assistant professor at Qatar University in Doha, and I'm specialized in comparative family law. So this is one of my inheritance law is one of my key interests. The objectives of today's training session for you are that we want to examine global best practices in inheritance law and then identify key challenges when it comes to transnational inheritance, so inheritance disputes across country borders. And then we will also briefly discuss the practical implications of our comparative analysis for UAE legal practice. So by the end of this training, you will all be able to differentiate between intestate and testate succession and testamentary freedoms in different legal systems across the globe, and you will be able to evaluate case studies from the selected jurisdictions that we will be looking at. And then finally, I'll leave you with the insights to apply these comparative perspectives to judicial decision-making in Dubai. So let us first take a very quick look at the principal ideas of inheritance law. And these are shared principles, shared common grounds for inheritance law across the globe. One of the principal ideas of inheritance law is to protect the family and to protect immediate dependence of the person deceased. So inheritance law wants to guarantee in different ways, and this will be a core subject of our session today, but in different ways, inheritance law wants to protect the financial security of spouses, of children, and then potentially of other dependents. And then on the flip side of this, the protection of family and dependents, the flip side of this is, of course, the respect for the deceased wishes. And this is where testamentary freedom comes in. So we have protection for dependents on the one hand, we have testamentary freedom on the other hand. And you will learn today that sometimes these two principal aims of inheritance law may in fact conflict. And inheritance law aims within these conflicts to prevent disputes and provide legal clarity. So the aim of inheritance law across the globe is to establish rules for estate distribution that are predictable and therefore prevent conflicts within the immediate family of the deceased. But another aspect of inheritance law is that it can serve to promote social and cultural norms, because inheritance law also defines who a family is and who requires special protection upon the death of a close relative. So through inheritance law, we can learn a lot about how a certain country, a certain jurisdiction defines the family and the core of society. And then finally, inheritance law wants to guarantee economic and property stability. So it wants to provide for a smooth transfer of assets in order to prevent property fragmentation. A point that is very important for the United Arab Emirates, where family businesses are quite common, is that you also, through clear inheritance rules, can guarantee business continuity, especially for family-owned companies. So these are all shared aims, but the jurisdictions that we will be looking at today differ quite significantly on how these aims and goals can be achieved. And the way through which we can identify those differences is comparative inheritance law or comparative personal status law, because that tells us how to analyze different jurisdictions and different legal systems across the globe, including in aspects of inheritance and personal status matters. Comparative personal status law will not only focus on statutory law, and instead it will actually take into consideration likewise case law, so how statutory laws are being interpreted by the courts, and then in some instances also customary practices, especially when those differ from the statutory law and potentially also the case law that is being established by the courts. So comparative personal status law is essential, of course, for legal harmonization. It is important for cross-border disputes, and it may, and I understand this is the case in the UAE, it may also inform reform efforts, because when we look at best practice examples from elsewhere, we can also understand the shortcomings of our own legal system and how we can potentially improve it to meet the regulatory needs of those that utilize this legal system. But despite the great potential that comparative personal status law holds, it also has some challenges. And these challenges are, for example, visible when it comes to the question of legal transplants. So what is a legal transplant? A legal transplant is when I take a legal concept or from one jurisdiction where it has been it has a long history, and where it has grown somehow naturally. If I take this concept and I implement it or I transplant it into my own legal system, a very common example would be the common law trust. A trust is and we will speak about that, is a common way for estate planning, dominant especially in the US, but also in the UK. Now, if we take the trust and transplant it into another legal system, for example, a civil law system, this may conflict with local legal traditions. So when I say conflict with local legal traditions, I don't necessarily mean considerations of public policy. I just mean that the overall system has not necessarily been designed to incorporate something as the trust. And another example outside of inheritance law would be civil marriage, for example, which is also alien to Islamically inspired legal systems, but has been introduced as a legal transplant. So it's not best practice examples should not be understood as simply taking something and transplanting it into a legal system. We also need to make sure that the overall framework around this transplant is one that can accommodate foreign legal ideas. Then comparative personal status law may encounter the challenge of conflict of jurisdiction. So we can have situations in where cross-border inheritance law lead to overlapping claims, where, for example, from the perspective of one jurisdiction, a different law is applicable than from the perspective of another jurisdiction. So we have claims that are not necessarily harmonized. Comparative personal status law can help us harmonize those conflicts, but it doesn't necessarily mean that certain conflicts of jurisdiction or even conflicts of applicable law will be resolved. And then, of course, for the United Arab Emirates, there's also the question of religious versus secular legal tensions or traditions and how they can be brought in harmony. So there are certain systems that that allow some flexibility to choose between religious versus non-religious law. And then there are other systems that strictly enforce religious inheritance law on people who are perceived to be of a certain faith. And we can even see that in the United Arab Emirates, where there's a difference between the majority of Emirates and the legal framework in Abu Dhabi, which defines the scope of application for civil family laws a bit differently, rather based on nationality than just a person's individual faith alone. So these are just some challenges that I want to flag to you so that you are aware of the limits of comparative comparative personal status law. But on the upside, the positive aspect is that the following discussion and the following comparative analysis, of course, also has many advantages. It can strengthen Dubai's role as a regional hub for cross-border estate planning, because if we are aware of how different jurisdictions address state and interstate succession, it will also help us to create a legal community where these differences are being respected and highlighted and considered when, for example, drafting wills. These comparative insights can also help us interpret the more recent civil family laws for non-Muslims when it comes to inheritance laws and how they can be developed further. I just mentioned the civil personal status law already. Just a very, very brief overview, but before I do that, I need to somehow try to move this. Okay, now I can see my full slides. Okay, so a very brief overview of the civil personal status law for non-Muslims in the UAE. You are, as I mentioned before, of course, you are all the experts on this topic. The principal piece of legislation governing civil personal status law is law number 41 of 2022, but there are other relevant legislative provisions, especially the conflict of laws rules in the civil code, which open up the possibility of applying foreign law rather than the civil personal status law on the estate of a foreigner who died. The law applies to non-Muslim UAE citizens and expatriates, you all know that, and it offers a secular framework for family matters, including inheritance, of course. What is more important than this general overview are the key provisions on inheritance for non-Muslims, and they are important because they also help us understand where the applicable law is already in conformity with best practices across the globe, and where potential conflicts of applicable law may arise. So one of the key principles of law number 41 of 2022 is the equal distribution of interstate inheritance between male and female heirs. The principal recipients of the estate are the surviving spouse and children. They are both entitled to fixed portions, namely 50% of the estate. Should a person die without a surviving spouse or without children, the estate may revolve to the parents or the siblings of the deceased. Apart from these rules on interstate succession, there are also extensive rules on wills and testamentary freedom. So non-Muslims have full freedom to distribute their assets via wills. And when I say full freedom, I really mean full freedom. And that will be interesting further down the line in our training session. One can, as a non-Muslim foreigner, you can register your wills under the Dubai courts or under the DIFC Wills Service Center. So we have two frameworks in which wills can be registered. If you opt for the DIFC, you will have a will under common law principles. If you opt for the Dubai courts, there's a bit more flexibility, and you can, for example, register a will in which you designate the applicable law, or one that is closer maybe to your law of nationality. So that's in a nutshell the system that you all are working with and that you are very familiar with already. And now I want to move from this overview of the local legislative frameworks to what you are really interested in and what you came here for today, and that is foreign law and international best practices in inheritance law. One of the main dividing lines for analyzing inheritance law across jurisdictions is common law structures and civil law jurisdictional structures. They vary significantly, especially when it comes to the question of forced heirship versus testamentary freedoms. And that, of course, results in quite significant differences in how estates are being distributed. And generally speaking, common law affords a much larger discretion to the testee, so to the person who drafts, who writes a will, whereas the civil law jurisdictions are usually in favor of certain compulsory shares in the estate of the deceased, especially for spouses and children. So the common law jurisdictions focus more on the individual and his or her desires, and the civil law jurisdictions rather favor state-imposed inheritance laws. And this can be seen, for example, in the UK, the US, and Canada, where we have a prioritization of testamentary freedom. And then opposed to that would be the examples of countries like France, Germany, Spain, who enforce compulsory shares and thereby ensure that a fixed portion of the estate passes to those heirs that the state has legally designated. As mentioned before, these are mostly children and spouses. Why is this important? Because expatriates, non-Muslim expatriates in the UAE come from all kinds of backgrounds and all kinds of jurisdictions. There's, of course, a large British and US American expatriate community in Dubai, but Dubai is home to expatriates from all across the globe, and that means also from many civil law jurisdictions that recognize forced heirship. And it's important that when you as legal practitioners and as lawyers, when you support individuals in drafting a will, that you have in mind not necessarily the details of the laws of their nationality, but a general understanding of the legal framework and how inheritance is being approached in the respective jurisdiction that the person comes from. The DIFC Will Service Center, of course, has made a tremendous difference in estate planning for non-Muslim expatriates in the country, but it has opted for a common law-based approach, meaning that it does not necessarily meet the requirements for many expatriates coming from civil law jurisdictions. So to make these distinctions between common law and civil law approaches in inheritance law clearer, I have selected today different case studies, and we will be starting with the home country of probably the largest non-Muslim expatriate community in the UAE, which is the jurisdiction of England and Wales. And the title for to classify this jurisdiction would probably be testamentary freedom with family provision claims. So we will look at both now. We will look at the commonly held testamentary freedom, but we will also look at legislative interventions on part of the state that guarantee that close relatives are provided for in case of the death of loved ones. The key principle of inheritance law in England and Wales is full testamentary freedom. So similar to what you know from law number 41 of 2022 in the UAE. Full testamentary freedom, meaning that every person within the jurisdiction is free to distribute their estate as they wish, without regard to certain dependents, including spouses. So if I make a will, I'm entirely free to distribute my estate as I please. I may also distribute it to a stranger, to a third party, to an organization. This general principle was altered significantly in 1975 when the Inheritance Provision for Family Independence Act was passed. And in a way, you can, with this act, you can see the civil law jurisdiction approach peers the common law jurisdiction of England and Wales, because through the 1975 Act, close family members can now contest a will if they were financially dependent on the deceased. Now, this is usually the case, certainly the case, when it comes to spouses. So if one of the spouses potentially wasn't working, devoted his or her entire time to the family and the spousal home, its upkeeping, then in the case of the death of the other spouse, and if that spouse did not afford a sufficient portion of the estate to the surviving spouse, he or she may contest the will. It can also include, of course, children being typical dependents, especially if they are minors and don't have an income. But it could also include adult children of the deceased. If there is any grounds to assume that there was a financial dependency on part of the children, then they may also, under the 1975 Act, bring forward claims to contest the will. And then the court, in handling this dispute and the estate administration, may afford a certain portion of the estate to the person who was financially dependent on the deceased. So the court has the capacity, the power to alter and amend a will that was drafted, even post-mortem, amend this will if there are dependents that have a solid claim to part of the estate because they were financially dependent on the deceased. And this was illustrated and confirmed in a number of cases. I would just want to highlight two for you. The first one is Illit v. Mitzen of 2017, in which the UK Supreme Court upheld the right of a mother to disinherit her estranged daughter, but the court also ruled that reasonable provision should be made for financial need. So the mother died. She had not included her adult daughter in the will, and the daughter did not have sufficient means. She contested the will, and despite the fact that mother and daughter were not in any kind of relationship during towards the end of the mother's life, the court still ruled that the daughter was in financial need, and that therefore reasonable provision should be made to sustain her financially. The case went back and forth between courts. So it started at the first instant court, where an award was made of £50,000. And this, and then the daughter's claim was that this money was not sufficient for her to, for example, buy property to live in, but it was too high to still receive state support. So it would actually bring her in a situation where her financial situation would be worse than before, because she would not be entitled to social support from the government, but at the same time, she was also not able to sustain herself financially. The appeals court granted the appeal and sided with the daughter and raised the amount, but then at the level of the UK Supreme Court, the appeal court ruling was actually reversed to the original amount of £50,000, arguing that sufficient provisions and reasonable provisions must be made for financial need, but that this does not necessarily mean that especially an adult child should quote unquote live carefree for the rest of his or her life without any financial concerns. So reasonable provisions, but not the financing of, for example, the purchase of property and significant jumps in the financial means of the surviving dependent. An earlier case from the late 1990s, Hancock, made clear, or in this case, the court emphasized the importance of making reasonable provisions for family members under the Family Provisions Act, and particularly in cases in which the financial situation changes considerably after the testator's death. So this was a case in which a man died, leaving behind a number of children, some of which he was partnering with in his family business. So one of his daughters and I believe 2 or 3 of his sons were partners in his successful family company, whereas 1 or 2 daughters weren't. And then for one of these daughters, who was also estranged from the testator, the will did not make any provisions. The family business was doing well, but nothing out of the ordinary, let's say. So the amount of the estate, the value of the estate was reasonable, but not millions of pounds when the testator died in the late 1980s. However, shortly after his death, the situation changed considerably when a plot of land on which the family company's firm was based and which they owned was bought by a large hypermarket company operator. And they ended up having a plot of land worth around £3 million. So the financial situation changed completely, and the daughter who was not considered in the will contested the will and applied for reasonable provisions. And those were granted to her, and it was recognized that it is that the court has the power to make reasonable provisions for family members, and especially in cases when the financial situation changes significantly, but again, only within the reasonable needs of the surviving dependent, and not on a degree with those dependents and children, spouses that were recognized in a will. So it is not upon the court to establish equality between children, for example, but is only for the court to rule on reasonable provisions, so that someone who was financially in need and potentially dependent on the testator is provided for. Now, of course, within the context of England and Wales, this must also be understood against the responsibilities that would otherwise fall upon the state. So in countries that have a robust, a solid social security system, leaving one of the dependents without provisions, without recognition in the will, means that the responsibility falls entirely upon the state and therefore upon the larger community if that person is financially needy. And this is a social background against which, of course, these provisions must also be understood. So what does that mean for legal practice in the UAE? If, for example, you're consulting a British expatriate in Dubai, and that person drafts a will under UAE law, entirely disinheriting a child, he or she needs to be aware that the child may challenge this will in the UK, in the home country, under the 1975 Act, which will then lead, of course, to potential enforcement conflicts between the UK and the UAE, because the UK court may find that a reasonable provision must be made for the child, whereas the UAE legal system would recognize the complete testamentary freedom of the deceased. So that's one end of the spectrum. And the other end of the spectrum would be civil law jurisdictions. France and Germany in particular, where forced heirship rules and reserved shares prevail in the inheritance system. The key principles of French and German inheritance law are as follows. France has opted for the most drastic form of forced heirship rules, where there are significantly high reserved shares for children, with a minimum of 50% if it's one child and a surviving spouse, but the reserved shares may go up to 75% of the estate if there are 3 or more children. So 3/4 of the estate are already devoted to, are already designated for children of the deceased, and it is only the remaining quarter that may be given away freely through a will. The situation in Germany is similar, but slightly different. There are reserved shares in German law, but there are also compulsory shares, and compulsory shares are generally half of the statutory shares. So if you die intestate, your estate will be divided based on the statutory shares, where the surviving spouse will first receive half of the estate, and then depending on the property regime, may also have ownership of another quarter of the estate, and then the remaining quarter would be shared among the children. However, if you do not die intestate, but you leave a will, and you completely disinherit your children or your spouse, then these dependents can challenge the will and will still be entitled to a compulsory share, which is half of what they would have received as a statutory share. So it would reduce to 25% for the surviving spouse, for example. It will reduce to half of 25% for the surviving children. So there's a statutory share and there's a compulsory share. And the compulsory share can never be excluded from the estate. And that essentially means that in civil law jurisdictions such as France or Germany, testamentary freedom is extremely limited. It only allows for a discretionary distribution of the remaining portion of the estate, everything outside the reserved shares, the forced heirship, which leaves the testator with very little flexibility, or at least with very little. A little part of the estate that he or she can freely dispose on and decide over. So in a sense, the civil law approach is similar to the approach in Islamic law, despite the fact that it does not have reserved shares for more distant relatives. But the principle is the same, that there's a portion of your estate which you can make free decisions over, and you can put in a will, and you can designate anyone you wish as an heir. But there's a larger share where it has been pre-decided who is entitled to receive this part of the estate. So remember one of the first slides earlier when I spoke about that principal aims of inheritance law, and that is to provide for close dependents, the spouse, the children, to guarantee that the family is provided for even after the death of a close relative. That is the main principle in France and Germany and other civil law jurisdictions, whereas the testamentary freedom is the ruling principle in England and Wales. So again, some practical examples from both jurisdictions. There was a very interesting case in the early 2000s that was ultimately decided by the German Constitutional Court, which confirmed that compulsory shares cannot be waived unless under exceptional circumstances. And what were these exceptional circumstances? It is, for example, it was the case of a son murdering his mother. So the case concerned a mother who lived with her two adult sons, and one of them was mentally sick. He was suffering from schizophrenia. And in an episode of rage and illusions, he attacked his mother and ultimately killed her. This, by the way, followed his realization that she had already made a will disinheriting him, except for the compulsory share, of course. So he was aware of that. He was in a stage of rage. He murdered his mother. And then the second son, who was also residing with them, was made named the sole heir. And the by then convicted son, who was in prison, challenged the will and claimed his compulsory share. And the court ultimately ruled that this was a case of exceptional circumstances in which even the compulsory share can be waived. But you see the threshold here for waiving the compulsory share is murder. So being estranged, having had a difficult parent-child relationship, children not adequately caring for their aging parents, all of this under German case law is not considered sufficient for the compulsory shares to be waived. In French law, there was an interesting court decision in 2017 that we will also look at again later, but the bottom line of the Cour de Cassation, the Cassation Court ruling, was that whereas France has these extremely strict forced heirship rules and these extremely high reserved shares, and this is important now for attorneys working in Dubai and dealing with French expatriates, reserved shares are not part of French international public policy. So should you draft a will abroad, and that will is recognized as valid under French law, and should you under that foreign law opt to not comply with the French forced heirship rules, this will not per se constitute a violation of international public policy or French public policy in private international law. So French citizens, in theory, have some degree of flexibility when drafting a will in a jurisdiction that recognizes larger testamentary freedom. However, and this is where the practical example comes into play, as long as there's a sufficient connection to the home country of either a French expatriate or a German expatriate, so if there's still a strong bond between the expatriate and his home country, if the children still reside in Germany or France, if part of the estate is located in Germany or France, and then this expatriate writes a will leaving all assets to a charity in Dubai, for example, then the children may very well be successful in either Germany but also France to challenge this will and enforce their reserved or their compulsory shares. So again, a complicated cross-border estate administration. I mentioned before that the UK, that England and Wales are probably one part of the spectrum when it comes to testamentary freedom vis-a-vis forced heirship, but actually the United States are an even further end of the spectrum. When I speak about United States as a jurisdiction, I want to highlight, of course, that as the name indicates, it's a federal state with multiple states and multiple state laws. So one state that stands out in the United States is Louisiana, which in fact is a civil law jurisdiction. So much more in line with those inheritance laws prevailing in continental Europe. But the remaining 50 plus states in the United States are all common law jurisdictions and have very strict rules when it comes to testamentary freedom. So they are very much in favor of testamentary freedom. There are, but now, some elective share laws, but they usually protect only the spouse. So similar to the England and Wales approach, some US states have provisions under which the surviving spouse can claim reasonable provision, a reasonable share in the estate. It's typically 1/3 of the estate. But there are two important notes. One is that this share, this elective share, can be waived. And it can be waived, and this is very common. It is, for example, being waived upon the conclusion of the marriage. So spouses in their prenuptial agreement may agree on an inheritance waiver, which then again grants full testamentary freedom to both of the spouses, or either of the spouses. So then an elective share will be considered waived. These laws also do not protect children. So while the US legislator or the US legislators have recognized that there is a certain financial dependency between spouses that must be considered upon death, they did not recognize that adult children, but even minor children, must be afforded special protection. And the most common form in which estates are dissolved in the United States are by use of a trust. So especially where someone dies with a significant amount of wealth that is usually being placed in a trust, a fund, that can then be used to bypass probate, but also reduce the tax burden. So it's the most common form of estate planning in the United States. Again, interesting case law, one from Texas, one from Illinois. The first one from 2016, a testator, a father, died and disinherited his daughter entirely. The daughter brought a claim against the will and argued that the disinheritance was entirely motivated by personal animosity and revenge. There were accusations of sexual abuse by the daughter on part of her father being brought forward, and it was argued by the daughter that the father only disinherited her out of revenge for her making those claims public. Still, and despite the daughter's financial needs, the Texas Appeal Court upheld the absolute testamentary freedom of the father. And another interesting case from Illinois is one in which a couple drafted a will in which they specified that they would disinherit, or that their children would be disinherited should they have married outside of their Jewish faith. So, of course, this clause was only effective retroactively, in the sense that should the children marry outside their faith before the parents die, then in this case, they would be disinherited. After the death of the parents, should the children have already inherited part of the estate and then decide to marry someone outside their faith, of course, this clause wouldn't become effective. But it was a conditional clause in the will, which in a way restricted the children's freedom to marry unless they agreed to losing a significant part in the estate. And even that clause was being upheld by the Illinois court. So if an American expatriate in Dubai decides to create a trust to distribute assets, even this division of assets may be challenged under state elective share laws. Certainly, if the American expat drafts a will disinheriting his spouse, courts may override even trust provisions to provide for a surviving spouse, but not necessarily the surviving children. So again, the full testamentary freedom that the UAE legal system currently recognizes for non-Muslims may find its limits in the home laws of these expatriates. So it is interesting to also look at how other hubs for expatriates across the globe have addressed local and expatriate needs. Singapore is a common example. They have full testamentary freedom under the Wills Act, but again, Muslim subjects are excluded from that, and they are subject to Islamically inspired succession rules. But what Singapore has also introduced is something very similar to the approach of England and Wales, and that is the Inheritance Family Provision Act, which allows dependent family members to challenge wills if they were financially dependent upon the deceased. Hong Kong also historically has followed English common law traditions, but again has introduced an inheritance provision for family and dependents ordinance, which allows family members to claim maintenance if they were not being considered in the will. But what Hong Kong has also been doing more recently is using trusts to manage cross-border assets. So the recognition of trusts as a legal transplant can raise the profile of a jurisdiction in the eyes of expatriates, especially high net worth expatriates, in managing their wealth across generations. So while largely based on English common law traditions, Hong Kong has also transplanted, including some of the legal experience of the United States to manage cross-border assets of high net worth expatriates. So against the background of all of this information and these this global overview of approaches in inheritance law, both testate and intestate succession, what are the practical implications? And what does that mean for the United Arab Emirates? I know that many of you are particularly interested in cross-border cases, and I'm just gonna highlight in the next few minutes some of the main characteristics or some of the most important features of drafting and then enforcing wills across jurisdictions based on the jurisdictions that we just looked at, and where we looked at the domestic inheritance law in detail. So in England and Wales, the general approach is that a foreign will may be considered valid. So, for example, a will drafted by a British expatriate living in Dubai may be considered valid if it was prepared in accordance with the requirements of national law. So that would be UAE law of the country in which it was executed. Or, for example, if it was prepared in accordance with the national law requirements of the country of which the testator is a national or had his habitual residence or domicile. So this would be the case. The second scenario is the case, for example, of a foreigner residing in the UK, but he executes a will in his home country, and then that will can be considered valid if it was prepared in accordance with the national law requirements of his home country. The other scenario would be a British citizen habitually residing abroad in Dubai, for example, and drafting a will in line with the laws of the UAE and Dubai locally. This will can be recognized, but again, if it can be challenged under the Family Provision Acts, but the will in itself will be considered valid if it complies with the laws of the country in which it was executed. Germany, I want to highlight, is a member of the Hague Convention on the Form of Testamentary Dispositions. And for those of you not familiar with Hague Conventions, I know the UAE hasn't ratified many to date. So Hague Conventions are international treaties on private international law and all fields of private international law. States they are drafted by the Hague Conference on private international law, and members can become part of these conventions to ease bilateral relations in matters, especially of private law. So the Hague Convention on the Form of Testamentary Dispositions eases the recognition of wills that are executed in member states and will usually lead to an automatic recognition of these wills. So most wills executed in another jurisdiction that is also a member state of the Hague Convention will be regarded valid, at least in terms of form. So being part to a Hague Convention, usually, especially for legal and judicial personnel, significantly reduces the burden of investigating into a foreign law, because if you look at the example of England and Wales as a foreign judicial, as a legal practitioner in the UAE, for example, or as a legal practitioner in England and Wales, you would have to familiarize yourself with the national laws of every single country in which a will may have been executed, or of which a testator may be a national, to then make sure that the will complies with this form and can therefore be recognized. Whereas in Germany, if you encounter a will from a jurisdiction that is part of the Hague Convention, this extensive investigation of foreign law lapses and becomes redundant, and you can simply recognize the will because it was drafted in one of the Hague Convention member states. So in cross-border disputes, Hague Conventions can really ease the work of legal practitioners. And now I want to come back to the case I meant from the French Cour de Cassation mentioned before, to just highlight private international law and public policy, and the questions of what kind of inheritance law can another jurisdiction bear to accept, even though it's significantly different from what the legislative framework it itself has passed. So I mentioned before, France being a civil law jurisdiction has very strict rules on forced heirship. It has very significant compulsory shares for children. And the question is, in how far can French nationals draft a will abroad that disregards these forced heirship rules? And that question was answered by the French Cour de Cassation, and not so long ago, in 2021, when the Cour de Cassation ruled that a trust established under California law, which only designates the wife as the sole beneficiary, and completely excludes the children, may still be recognized in France under certain conditions. In this case, it was actually a joint application there was joint cases that had a very similar background. So two French nationals had been living in California for a long, long time. They both remarried in California. They both created trusts to manage their estate. They both designated their respective wife as the sole beneficiary and excluded children from previous marriages. These French children then challenged the will, the respective estate planning, the trust, before the French court. And in both cases, the French court ruled that under these specific circumstances, forced heirship must not be regarded part of French public policy. But it was also because both cases did not contain a significant connection to France anymore, as both testators had left the country a long time ago, had been habitually residing in California, had no family ties to France anymore. So it was not considered to constitute a violation of French international public policy that they completely disinherited their children, as was possible under California law. So what does that mean? It means that one practical consideration in drafting and then enforcing cross-border wills or transnational wills is questions of public policy. It is questions of conventions under which an automatic recognition of wills is necessary, and it is a question of are certain countries, certain jurisdictions included in the group of origins from which a will can be regarded formally valid if it meets all the conditions. So habitual residence, for example, nationality, etc. So all of this can be relevant when you draft and when you enforce a cross-border will. So what are the key, and I see we will actually get to the Q&A session earlier. So what are the key takeaways from all of this? One of the key takeaways that you will have noticed already is the constant conflict in inheritance law globally between testamentary freedom on the one hand and protection for close dependents on the other hand. And this is actually something that equally plays out as a conflict in the United Arab Emirates. We know that, and I mentioned that in the beginning, under Federal Law number 41 of 2022, currently non-Muslims have significant testamentary freedom, right? And this is actually the main factor that distinguishes the inheritance framework under Federal Law number 41 from the inheritance framework for Muslims under Federal Law 28 of 2005, but soon Federal Law number 41 of 2024. So testamentary freedom in the UAE, as envisioned now, very similar to the approach of the United States. So it allows individuals to distribute their estate entirely according to their wishes. So this aligns the UAE legal system more closely with common law jurisdictions like the UK, but specifically the US, where also individuals have significant discretion in estate planning. But the question is, in how far should this be balanced with the need to protect close dependents, right? So this would be the other approach that we have also seen in civil law jurisdictions, but also in common law jurisdictions like the UK or the US, to ensure that individuals' dependents are not left unduly without support after the death of a close relative, okay? So to recognize in a way that there is a financial relationship within the family that cannot just be ended by will of one family member, even though he or she, of course, only disposes of his or her property. So to recognize that in a way the state may want to interfere in the distribution of the estate to make sure that certain individuals within the family are protected. This is the approach that the UK and to a lesser degree the US have also taken. So one approach could, for example, be to take this common law inspiration and take something like the UK Family Provision Act as an inspiration and have a legal framework under which close relatives such as spouses, children, but also possibly other dependents, parents in the UK, of course, can also bring forward a claim under the Family Provision Act, and if if there's credible reason to believe that they were financially dependent upon their children who predeceased. So to say one best practice example from the UK would, for example, to be, we recognize that there are certain financial ties and interdependencies within families. Those go beyond just the spouses, and therefore, despite upholding the principle of testamentary freedom, we do have a legislative framework under which close family members can challenge a will if they believe they have not received the adequate portion or adequate provision from the will. And then the court can decide that a certain adjustment of the will needs to take place to distribute the estate more fairly and therefore adequately provide for family members in need. Hong Kong and Singapore have taken this path. They have essentially followed the example of England and Wales and have introduced similar provisions for dependents through the two respective acts that I mentioned on my slides, so that there are situations where a close family member has been financially dependent on the deceased is left or inadequately is left out of the will or is inadequately provided for, and then these provisions could become operative and the court would decide what the reasonable provision would be. If we draw inspiration from the civil law systems, then the situation would be entirely different. We would have as examples, or best practice examples from civil law jurisdictions are quite the opposite of testamentary freedom. They are forced heirship. It is the state that decides where the estate or a large part of the estate should go, always making sure that a certain portion of the estate is reserved for children and spouses. So that also demonstrates the cultural underpinnings of civil law jurisdiction inheritance provisions and how civil law jurisdictions perceive the family as being a core unit out of which where you cannot really opt out and not push someone out when it comes to financial provisions. even if your individual desires are different. And again, the approach of France would be that you always receive your reserved portion. And similar to Islamic law, the testator may only freely dispose of a very small part of the estate, whereas in Germany it's a little different. You will receive a certain portion, but if the testator's will are that you should be disinherited, then you will only receive half of what the legislator originally envisioned as the reserved portion of you. So if the legislator has a certain preference, the testator may deviate from that, but if he or she deviates from it entirely and disinherits children, they may still claim their half of what their statutory share would be. By the way, it doesn't mean that this always happens. So in Germany, which is my home country, so I have probably the broadest practical experience, but people leave wills disinheriting children and maybe even estranged spouses all the time, and that doesn't necessarily mean that these people will not automatically receive their compulsory shares. For many children, especially who are disinherited, that's a clear statement on part of their parents, and they will just leave it at that. They will not necessarily challenge the will. So the testamentary freedom in many cases is being upheld, but if children object and challenge the will, then the legislator has designed a process by which they will still receive reasonable provision. Of course, the UAE has, as of now, the current inheritance system in the UAE is one that really appreciates full flexibility, similar to the US or England and Wales. So forced heirship is probably not the way to go as a best practice example, but there could be minimum provision rules for dependents that sort of offer compromise between testamentary freedom and the need for family protection. But there's also, and I'm going to highlight one more best practice example from a different jurisdiction here, because a similar approach has been taken in Australia. There's also the possibility to simply have a judicial review of unfair disinheritance. So in this case, the responsibility wouldn't even be on the legislator to choose one system over another, but rather on the courts to review potentially unfair disinheritance and correct it accordingly. So what can be done and what can be drawn as a conclusion from these best practice examples is that one can introduce a judicial review mechanism through which courts can step in and adjust a will whenever they see it, whenever they consider it necessarily, specifically if courts feel and are of the view that a certain dependent has been unfairly disinherited or given a disproportionately small share. So think of the two case studies or the two case law examples I gave you from the United States. One where a daughter claimed that her father had only disinherited her out of revenge, and the other one where the children were disinherited should they have married outside their faith. Okay, so these would have been cases where if you had a judicial review, the court may come to the conclusion that it constitutes grounds for unfair disinheritance, or that the portion that a certain child is given is disproportionately small compared, for example, to other children, and then the court can intervene and make reasonable provisions and adjust the will accordingly. So the general freedom of the testator would be upheld, but the court would also prevent extreme hardship and adjust that accordingly and guarantee that all dependents are cared for even after the death of a close relative. So again, this is the approach. This is another example, best practice example from Australia, where courts have this authority to provide relief whenever an unfair disinheritance is being established. And then just finally, just a few notes on the practical steps all of these best practice considerations entail. If you draft wills for expatriates in the United Arab Emirates, bear in mind considerations for dependents. So given the fact that across the globe, there's almost no jurisdiction, with the potential exception of the United States, where testamentary freedom is upheld to a degree that you can completely ignore your dependents when you draft your will and you make provisions for your estate. Given the fact that almost all major jurisdictions around the globe have some sort of statutory provisions or case law that will that orders reasonable provision for close dependents, at least for the spouse. It is important to encourage expatriates to carefully consider what they write in a will and what potential legal challenges from family members may ensue in their home countries. There are tools, of course, like trust that can be used to ensure that estates are managed in a way that supports dependent family members, but still respects the testator's wishes. Like I said, Hong Kong has taken the approach of incorporating the trust into their legal system as a legal transplant to allow for high net worth expatriates to manage their estates according to their wishes. But one should always remember to advise clients about the possibility of family provision claims or other legal provisions for dependents in case the estate, the will, is being contested.